All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. Joining me on the panel for today's argument session for all 6 cases we'll be hearing this morning are Justices Kenneth Desmond and James Lemire. Our first hearing this morning is a telephone conference with a gentleman who is participating by telephone. That case is case number 2019 P861 William J. NADWORNY versus CHARLENE Bonner and others. Mr. NADWORNY, you may begin.
Good morning, judges. For the record, my name is William NADWORNY and I am a pro se plaintiff appellant. Thank you for this opportunity to speak to the court, especially during this unprecedented time. With that said, I will endeavor to be as concise and poignant as possible. In addressing this case, I would like to begin by stating that this case was brought forth after a determination was made of an incomplete record, that being a statement made at the May 12, 2015 parole hearing by then Chairperson CHARLENE Bonner, but does not appear in the DVD recording of that hearing. My parole hearing, as with any legal procedure, can only be considered final when the appeal is complete. As such, a complete record of the proceeding is necessarily required to complete this appellate process, notwithstanding the fact that the incomplete record may have materially impacted my entire parole process. It is incontrovertible that my parole eligibility proceeding is and can never be finalized because of an incomplete record. I also want to bring to the attention of the panel that this claim is both a civil rights violation under the Massachusetts Civil Rights Act and a court action concerning an incomplete record, fraud, and misrepresentation involving incarcerated parties. It is not an application for certiorari review under Massachusetts General Laws, Chapter 249, Section 4, as the lower court claimed in its judgment of the defendant. This ruling is contrary to the error in the parole board's record, demonstrative of the importance of an accurate record raised in this court action. I remain in limbo due to the fact that the 5-year review hearing should have taken place in March of this year in accordance with an order from this court in NADWORNY versus Umbrella. And most importantly, due to a conflict of interest that currently exists concerning members of the board, which has been formally brought to the parole board chairman and deputy legal counsel of the agency some 7 months later. The issue has yet to be resolved, though this issue is currently not before the court. I request this court to reverse the judgment entered by the lower court and send the case back for further proceeding or discovery based on the fact of a claim of an incomplete record and the result of a conflict between both parties in reference to the missing statement from the record. This is clearly a due process violation. The why cannot be answered until the incomplete record is resolved.
Mr. NADWORNY, this is Chief Justice Green. I have a question for you. As I understand the posture of the case, it was incumbent on the motion judge to assume, for purposes of ruling on your on the Commonwealth's motion, that a complete record would be, as you have represented it, would be. In other words, that the portion that does not appear on the record included the statement that you allege in your complaint. Is that correct?
That's correct.
Okay, but my understanding is that the motion judge assumed that statement would have been would appear on a complete record, and as I understand it, has concluded that even if that statement were present, it would not affect your right to relief.
This is more of a due process issue of an incomplete record. We don't know the why, if it was done, if it was intentional or not, Your Honor. So that's the question that needs to be answered, because if it was intentional, then this is a serious due process issue. So
I understand that that's your claim, but if if we accept as a factual premise that that statement would have appeared on the record, what effect would that statement have on your rights and remedies?
I believe if the statement was deliberately taken out of the record, it could, at this point, because they can't grant me a new hearing, it could entail damages based on the fact that it's an incomplete record.
But if the omission from the record is immaterial, then the omission would not give rise to a remedy, right?
That would be correct, Your Honor.
So what I'm trying
answered, so we can't make that determination at this point.
Well, what I'm trying to ask you is, if we assume, for the sake of this inquiry, that the portion of the record that does not appear in the record that you say should appear in the record, what would that addition to the record provide to you by way of a right or a remedy?
I believe that the only thing that's available now, because I'm past my March 2020 parole hearing, would be damages if it was deliberate. That would be the only.
Well, no, but my question is, what damages, what difference would it have made if that statement were included in the record to begin with?
Well, I would say this, Your Honor, based on the fact that I have ran into this problem before, and I believe that they delete information off the record, and that wouldn't be appropriate in any type of hearing if it was done deliberately. That's the issue here.
No, but if the information, it would of course be troubling to have anyone deliberately manipulating a record. But if the information that is omitted from the record is utterly immaterial, if it doesn't matter in any respect, then it's not clear to me what remedy would flow from that.
I'll put it this way to Your Honor. I think the best way to explain this is that the information substantiates the fact that I was misled prior to the hearing, including counsel that represented me, that they would not retry the case. And we focused more on my incarceration, my parole plan, and a different outcome if they didn't retry the case may have been in existence if I was more prepared at the hearing.
I understand the claim. Thank you.
May I continue, Your Honor?
Of course.
A showing has been made through multiple affidavits of supporters who attended the hearing and a letter from counsel who represented me at the hearing. The complaint does infer all the elements of a tort claims, fraud, and misrepresentation, along with other statutory acts stated within the complaint and outlined in the reply brief. Thank you once again for the time before the court.
Thank you, Mr. NADWORNY.
So I just want to be clear for a moment, Mr. NADWORNY. Your position isn't that the outcome of the parole hearing would have been any different had the statement been in the record that was provided to you. Is that right?
It would have provided a reason to show that I was not prepared for the hearing based on the fact of misrepresentation, because I was not prepared because they informed us that they weren't going to retry the case.
And who informed you of that, sir?
I was informed by, counsel was informed by the Lifers Unit, and I was informed by the Lifers Unit parole officer, Eves.
Are you still, did we lose him? Are you still there, Mr. NADWORNY?
Yes, I am.
And when you say counsel, do you mean your attorney?
Yeah, my counsel was informed that we were just gonna, the hearing would be based on, it wouldn't be retried as in hearings past. I mean, I was cross-examined thoroughly through this entire thing. I did not read the transcripts. They were bringing up forensic evidence. And I think it would have changed the hearing if they just, it was focused on what the intention was by the, that was given to my lawyer and myself.
So your claim is that you were placed at a disadvantage in your opportunity to make a fair presentation at your hearing because you went into the hearing believing that it was going to go in one direction, and instead it went in a different direction.
That's correct. I did not read the 16 volumes of transcripts in which they cross-examined me on, even though I have read them in the past, but 35 years has passed, and I have read them over the years, but not recently. And I had asked the attorney if I should go over everything, and he said it would not be necessary because he was informed that they would not retry the case.
And other than the representations, this is Justice Lemire, other than the representations by the Lifers Unit, is there anything that you suggest that legally prevented them from asking you those questions?
I think that they can ask me questions about the crime, but retrying the forensic evidence and all in the transcripts, I mean, it was more of a cross-examination. There's a difference between asking questions and cross-examining me, and the whole hearing was based on cross-examination of issues in the trial transcripts, a lot of it to do with the forensic evidence, and I am not a pathologist, so I really can't answer that, though I understand my case.
I understand that, but is there any legal bar from them asking you that? Is there any case law, statutory law that prevents them, regulatory law that prevents them?
Well, I would say that this is an equal protection issue. They haven't been retrying other inmates, and for purposes of this hearing, that was the statement on the record saying they were just going to retry me, and they're not doing anybody else. I mean, and they told me that they wouldn't retry the case.
And you've participated in parole hearings in the past, is that right, sir?
Could you please repeat that? I did not hear.
You've participated in parole hearings in the past.
I have. I was retried at all hearings 4 times prior to that.
Is there anything else, Mr. NADWORNY, that you'd like to say?
No, I think I've covered all the ground.
Okay, Justice Desmond, Justice Lemire, do you have any further questions for Mr. NADWORNY?
Nothing further.
Okay, thank you very much for your argument. We'll hear from the Commonwealth.
Good morning, Your Honors. Jennifer Zelnowski, representing Charlene Bonner and the Massachusetts Parole Board. First and foremost, even if some of the plaintiff's allegations are true that he submits in his complaint, the Parole Board did not improperly retry his case just because they asked him questions about the underlying murder. As Mr. NADWORNY just acknowledged through Justice Desmond, this was his 4th round of parole hearings. So certainly he would be accustomed to the idea of being asked about some details about the underlying crime. But as was also pointed out by Justice Lemire, there's nothing that prohibits the board from asking those types of questions. In fact, the regulations and statute and significant amount of case law not only contemplates it, but requires it, because that's how the parole board makes some of its determinations. So of course the parole board is allowed to ask him questions about the underlying crime. And so that shouldn't be deemed to be somehow an equal protection violation in this particular case. It happens all the time. It's part of the regular process of the parole board. I also wanted to point out again as well that even if the statement that Mr. NADWORNY claims was taken out of the DVD, which of course the parole board denies, it doesn't have any impact on the outcome of this case. He hasn't established any prejudice. He hasn't, in fact, he has made it clear that he's not actually challenging the underlying decision. He's just making this claim that this line from the chairperson was removed from the DVD.
Well, what, counsel, this is Justice Lemire. What do we do with the allegation that there was tampering with the record? What do we, that's like a separate claim here that he claims is a due process claim that the record was tampered with. And he's suggesting it should go back to at least have discovery on that issue. What do you say to that?
Well, I think that because this court is reviewing under the Superior Court's 12b6 motion, this court should take into consideration that the Superior Court judge found that the facts weren't sufficient in this particular case, and the allegations just weren't plausible. And even with reasonable inferences drawn in his favor, wasn't enough to support his allegation that there was some kind of tampering with the DVD. And I think, as we pointed out in our brief, the chairperson made another statement very similar to the one that he claims was removed from the DVD. And it's more likely that there was some kind of misunderstanding with regards to that. In fact, she uses the word, uses the word retry and in a similar way, and I apologize, I don't have the words right in front of me, but basically says, we don't normally retry the cases, but we do have to go over the facts, and that's what we're going to do.
That kind of factual reconciliation is something that goes on at a later stage in a case, not at the motion to dismiss stage. For purposes of reviewing the motion, the ruling on the motion, you acknowledge that we don't credit your version of the facts and discredit his, right?
Oh, certainly, Your Honor, that would be the correct standard. All I'm suggesting is that even under the standard where you would assume that his facts are correct, there are still standards that have to be met, and so conclusory allegations don't meet the standard.
Well, didn't he submit affidavits from 3 other witnesses who also claimed that they heard the statement live for the 2-minute time period where it was alleged to have been made, and now it's not in the record? Didn't he submit affidavits of other witnesses who support his contention?
He submitted affidavits in the Superior Court. They weren't submitted as part of the record here. I would suggest that, so we don't actually have those affidavits in this record to review. In addition, he didn't really raise that argument sufficiently in his brief here, so there's also a waiver issue. But aside from all of that, I would suggest that those affidavits under the plausibility standard that's required for a 12b6 that plausibly suggest that he's entitled to relief, I just don't think they are. I think it's a little suspect that they are all exactly the same. And the
affidavits were not part of the complaint. So if there were affidavits, that would be extra evidentiary material outside of the complaint, and we would be in Rule 56 territory.
That would be correct, Your Honor. And they're also not part of the record here. Mr. NADWORNY didn't submit them as part of the record in his record appendix. They are referenced very briefly by the Superior Court judge, but they weren't included in the record. And in fact, on this particular issue of the 12b6 ruling, I would point out again, as I did in my brief, that he just makes a fleeting claim that he asserted sufficient facts, but he doesn't really make a fully developed legal argument on those grounds. I
just want to go back to so that we can all have a common understanding of the posture of the case as it stands before this panel. You heard my exchange with Mr. NADWORNY that for purposes of adjudicating this appeal, our task, much like the task of the motion judge, is to assume that his allegation that the record of the hearing was altered and that a statement was removed. It's for our obligation is to assume that that statement is true, right?
Yes, Your Honor.
Okay, and so if we accept that that statement is true, then the ruling allowing the motion to dismiss is correct if, despite the truth of that statement, there is no right or remedy that Mr. NADWORNY could realize, correct?
Yes, Your Honor.
Okay,
yes.
You've heard his response to my questioning on that question was that he was placed in an unfair, disadvantaged position because he was led to believe that he would be heard on his parole application on one basis and was instead heard on a different basis. And he claims that that was a denial of due process. How do you respond to that claim?
Well, first I want to respond that that claim has been developed over time, and that is not what appears in the original complaint. The statement that he makes in his reply brief that he was informed, not by his counsel, but by somebody else, that this is how this hearing was going to go. That's the first time that that's ever appeared. So I think that's important that the story has changed from the complaint to his opposition to the motion to dismiss, to his first brief, now to his reply brief. And so
can I just interrupt for 1 second? He says
yes.
that information came from the lifers unit. Is that an arm of the parole board, or what relation does the lifers unit have with respect to parole hearings, if any?
My understanding, Your Honor, and I apologize, I don't know the total nuances of how it works, but there are parole, I'm not sure if they're officers or how they work, but there are parole staff that are in in the facilities that they have correspondence and discussions with the inmates. It's not something that I am 100% familiar with, Your Honor. Only from another case do I even know that. So, but again, I think that's something that has come up over time, and I question that to be the case, because the parole board has always operated in this process. They have always asked detailed questions about the underlying crimes. They are authorized by the regulation, by their statute, and the SJC cases that discuss parole board, that this is how this process works. It's part of how the board determines whether or not somebody should be released. So if there was some misunderstanding, but again, this is also Mr. NADWORNY's 4th time in front of the parole board. So it shouldn't have come as a real surprise to him that the parole board was going to go through this process. They've done it before with him, and this is how they do things. Now, obviously, in certain cases, the questions are going to vary depending on how the candidate presents himself and how he answers certain questions, but it certainly isn't prohibited in any way, shape, or form. And again, if we're doing this if we're reviewing a 12B6 motion, one of the most important things to keep in mind is you have to go all the way back to the complaint. And how was this alleged in the complaint? And I think when you look at the complaint itself, you'll find that he doesn't meet the standards. And if you even the
claim of an unfair surprise appears, as I read it, in paragraphs 44 and 45 of the complaint on page 9.
Yes, he makes the allegation. I'm sorry, Your Honor, if I was misleading. He makes the allegation that that's what happened. How he gets that information is what changes over time.
Okay, but let's set that apart for the moment. I need you, if you can, simply to respond to his contention that he has a cognizable claim of a due process violation and suffered prejudice as a consequence by virtue of the misrepresentation or the changed expectations that he would confront when he appeared at the hearing.
Well, I just don't think that he meets the allegations for that type of claim, Your Honor. Like you said, even if you assumed that this statement was made at the last minute, he hasn't established any type of due process violation. He certainly hasn't established any type of prejudice, nor has he established any potential change in the outcome of this case. And in fact, he has made it clear that he's not challenging the decision in this case, and also waived his certiorari petition that would have been his challenge to the board's decision. So I think it's multifaceted as to the reasons why the Superior Court's decision should be affirmed in this case on this one particular issue. I don't think he has established a due process violation merely by making a claim that this sentence was taken out of the DVD, or that even if the chairperson said it. But the reality is that's not what she said. That the reality is she did make a reference to, we don't retry cases. They didn't retry the case. They asked him questions about the underlying murder in this case, which they are authorized to do under every part of their authority. And that's what happened in this case. So I think it is not supported enough in his complaint that there was some kind of surprise element going on here. Again, taking the standard in, his factual allegations have to show have to be plausibly suggest an entitlement to relief. And I think when you look at that kind of language, that's not what happens in this case. He just doesn't get to that point. And if there are no other questions, I'll rest on my brief for the remaining issues.
Okay.
Seeing no questions, thank you both for your argument.
Thank you very much, Your Honors.
Okay, we will return to the waiting room and admit the parties for the next case.
We are live and on the record.
Okay, the second case on our session this morning is case number 2019 P1018, the Commonwealth versus Jennifer M. Garvey. Mr. Scully for the defendant.
Yes, Your Honor. Thank you very much. I represent the defendant in this case, Jennifer Garvey, who at the time of the incident was a police officer for the MBTA Police Department. In this occasion, she was charged with committing a number of assaults and batteries, originally by dangerous weapon, a civil rights violation, and filing 2 counts of a false police report. She she was indicted on those charges, elected to have a bench trial, which she had. At the time of the bench trial, she was acquitted of any civil rights violation, but was convicted of 2 counts of assault and battery, one of which was a lesser included offense of the ABDW offense. She was also convicted of 2 counts of filing a false police report. She was sentenced to a short period of incarceration, which she served. A suspended sentence was imposed for the balance of probation, which she has also at this time completed. I have filed a brief on her behalf asking the court to reconsider her convictions, 3 of the 4 convictions that were in place. The 2 assault and battery convictions and 1 conviction for filing a false police report.
Your principal challenges, as I read your brief, are directed to the sufficiency of the evidence.
That really is the case, Your Honor, as well as the proper, I guess, jury instruction or self-instruction, as the Commonwealth characterizes it, which I think is a fair characterization for the court to apply the facts as it applies to the police privilege defense that was raised by Ms. Garvey's trial lawyer.
To that latter point, what do you point to suggest that perhaps the judge did not instruct himself properly with respect to police privilege? I think it hinges on the police privilege aspect of your defense. But you had a charge conference. He told you what he was going to consider. I didn't see any objection to that. And he talked about the Asher case and the model jury instruction. So what do you point to suggest that perhaps he didn't properly instruct himself?
In reviewing the transcripts in this case, it struck me that there was an element of confusion amongst all of the parties as to how the police privilege would be applied and what the proper standard was. The Asher case, which seems to be the one that most people think of when in terms of the police privilege, is basically a case involving self-defense, and the self-defense jury instruction, which was contemplated, also has a footnote about the police privilege. But it seemed like the parties did not wrap their heads around the clear application of the police privilege in this case. It is an affirmative defense. I do think that, I know this sounds odd, but it seems like the parties were getting close. I know at one time the trial prosecutor said, we're looking at this, but it's the wrong faucets that the instruction applies to. And the trial judge at the time, seemed to be onto that idea that they were in the right ballpark, but nobody ever enunciated clearly that once this privilege was raised, that the Commonwealth would have the burden of proving beyond a reasonable doubt that Officer Garvey did not used excessive and or unreasonable force in fulfilling her duty.
Isn't that though where the presumption kicks in?
I would respectfully say that there shouldn't be a presumption in this case where the judge didn't articulate an understanding at all of the law, where he did, I think, misarticulate what law would apply.
I think the silence by the judge is not going to get you past the presumption. I think you're going to need to point to something that's awfully definitive to suggest that the judge expressed a demonstrably incorrect understanding of the law. And I guess if I'm reading between the lines of Judge Desmond's question, I think he and I are on the same page. I need you to spell out with some particularity for my benefit just exactly where that demonstrably incorrect understanding is supported by the record.
Well, I guess I thought that his final phrase where the court said, I'll apply the law set forth in Asher and get back to you if I reconsider that. I'm paraphrasing because the charge conference in this case took place a day or so, or a hearing or so before closing arguments in the case. And Asher does not state the correct burden of proof. So I guess that is my argument, that there's more than just a silence here. there's the Asher case, I would suggest misstates the law, the application of the law.
You also have the model instructions.
And the model instructions are the self-defense instructions, which I would say are a bit of a red herring here. I thought the court noticed that and expressed a deep skepticism, I think, about whether this was a self-defense case. It was not a self-defense case. I don't think that would have been an effective defense at all. It was a police privilege case.
And so we had an opportunity to view the video, and I presume you have as well. So what if, in comparing the video to her report, the court didn't find her allegations of the victim bumping her and interfering with her process? What if he just discredited all that? How does that impact your privilege argument?
Well, this is a case where and in my brief, I attempted to just point the reviewing court's, your court's attention to the video. I have shied away as much as possible from relying on testimony that where one side portrayed the events one way and maybe another side portrayed it the other. I think the whole story in this case is captured in the video, and particularly in station cameras 1 and 3. As far as the reporting aspect of it, I did not challenge the report that is set forth in the Commonwealth's brief on the use of force. I think that use of force report was, we concede materially inaccurate. But the initial incident report that was filed by Ms. Garvey, I think, did capture, in all material respects, what happened. What I find interesting about this case is that this case, to my great surprise when I took it on as a lawyer, there's not a lot of clarity out there for the public or for police officers in how much police officers can use unless the public and the police officers start reading between the lines in the Asher case and the footnote of the self-defense instruction. And I think that's a problem in current times. And this case really goes to a lot of what we see, happening, on and off the streets all over the place, but here in Boston and in Massachusetts. And that is, how much interference does any police officer have to take before they can use a reasonable measure of force to carry out their duties in this case? And Ms. Holmes in this case, I would say would be, there's no rational trier of fact that could say that Ms. Garvey used an unreasonable amount of force. With all due respect to Ms. Holmes, she injected herself completely unnecessarily deeply into the personal space of a police officer who was armed with her gun at her side and disobeyed a number of requests by Officer Garvey to back up, to move away, to give her some space until, from our perspective, Ms. Garvey was just out of options at that time.
Oh, that's contradicted by the other officers, though.
I think it's contradicted somewhat to what the other officers perceived from their own perception. I'm not sure that officers Trin or Curry were in a position to see everything. They testified as to what they saw at the time.
But you understand that we take their testimony in the light most favorable to the Commonwealth for purposes of your contention on sufficiency.
I do, and I think to the extent that it's blatantly contradicted by the videotape, I think it would be an ironic and somewhat sad result to take testimony that's wrong when you have videotape that is clear. And
tell me about the blatant contradictions that the videotape displays.
I think the most blatant contradiction was when Ms. Holmes basically swings her elbow into into Officer Garvey, and at that point, I think you have
that characterization occurred midway through the physical altercation, didn't it?
I would say it's at the beginning of the physical altercation. What happened is Ms. Garvey had been on several occasions pointing with her finger, asking Ms. Holmes to back up and move away. Ms. Holmes was making a phone call.
She was calling 911 to report a concern about Garvey's conduct.
That's correct. And I think at one point she says on the audio, which is also part of the exhibit, this officer is telling me to back away. And Ms. Holmes is not backing away.
Well, she says she is. She says she is backing away on that video, and it appears that she might be backing away on that video. It's not until Officer Garvey starts to push her and places her arm on her, they kind of round the corner from the video that I could see anyhow, to just beyond the side of the I don't know if it's a sitting area for the T or the bus, whatever that encasement was. And so the altercation becomes a little bit blurred, I'd say. But nevertheless, at that point, when she's just on the phone and she's off to the left, how is she interfering with what the officer's doing with respect to the other woman who's to her right?
Well, if I understand the court's question correctly, I think that the interference with, I don't think there's much interference at that point with officers Trin and Curry and whatever they're doing with Miss Williams. I think there was interference in what Officer Garvey was trying to do with Miss Williams initially. And then at some point, the nature of the communication between them turned, and Officer Garvey turned and brought her full attention to Miss Holmes for a period of time.
Well, full attention followed by pepper spray and a baton to the kneecaps.
Yes, eventually. I mean, look, I don't think anyone thinks this was a good result. Certainly.
Well, no, the question is whether the force that she used was reasonable in the circumstances, right? Right. And the reason that it strikes me as unfortunate but reasonable, if that can make sense, is that when Miss Holmes refused to obey the officer's commands to back away, and stayed basically, in some cases, within inches of Officer Garvey, when Officer Garvey had to basically stop doing her job as it related to Miss Williams and turn and then use her left hand to put on basically the shoulder upper arm area of Miss Holmes in an effort to.
So why would she have to do that? Why? If Miss Holmes is just on the phone, why couldn't Officer Garvey just ignore her and continue on with whatever she was doing with Miss Williams? Why did she have to stop and focus on Miss Holmes, who's just on the telephone?
I would suggest that police need to have some zone of personal safety, especially if they have to turn their back and leave their weapon exposed to whoever is behind them. And the problem in this case was Miss Holmes got so close and was leaning in over the shoulder of Officer Garvey so frequently that was earlier in the encounter. She was told to back away. She was further away when she picked up the phone and started dialing, and it's at that point that the defendant went after her. At least based on what I saw in the video. It's funny how we can all watch videos and see different things. I never thought that Officer Garvey went after Miss Holmes. My take on the video, whether it's irrational for someone who hears two officers who were percipient witnesses testify to that effect and then watch the video that you and I both saw, whether it's irrational for someone to apply that interpretation to the events. Oh, I guess with all due respect, I think it is. It strikes me that at that point, after the elbow was swung by Miss Holmes, that was, in my experience, as I'm usually on the other side of this, right? I defend thousands of individuals and next to no police officers. But on this case, here I am with Officer Garvey, and I'm glad to be here on her behalf. But what happened was when Miss Holmes swings her elbow into Officer Garvey, that is an assault and battery against a police officer. It's a rank and file assault and battery against a police officer, the type that is filed in courts of Massachusetts hundreds, if not thousands of times a year. Where did the pepper spray occur? I will confess, we have multiple camera angles on this video, but I found it difficult to be able to tell precisely at what point the pepper spray was applied in that sequence. And I think there are two that matter. I think this is a factor for the trial court too. I think the trial judge might have been confused by this as well. It's camera 1 and station camera 1 and station camera 3 that matter. Those are the two camera angles. The rest are configurations put together by the Commonwealth basically as trial exhibits to maybe make things clearer in their view. They put a timer on there, which helps. But it's station camera 1, which shows the bench, which shows the altercation from that angle. And it's station camera 3, which shows from across the bench. And that's the angle you can see either the first or second burst of pepper spray basically substantially miss Miss Holmes. So from station camera 3, that's also where you can see more of the struggle that led to the baton strikes, including several blows. Well, okay, and now you see what I mean when I referred to the unmistakable end of time.
I have no further questions. Justice Lemire, Justice Desmond, do you have any further questions?
I do not. Thank you.
Okay, so we will hear from the Commonwealth. Thank you, Attorney Scully.
Thank you, Your Honors.
Good morning, Catherine Sherman on behalf of the Commonwealth. I'd also like to acknowledge ADA Michelle Granda, the trial prosecutor for this case, who is joining via the YouTube channel. As the court has noted, the video evidence in this case is the most important evidence. I'd like to draw the court's attention to Exhibit 5. And Exhibit 5 shows the 4 camera angles in a 2x2 grid. It also has the overlay of the 911 call. And from this video, it's undeniable that the Commonwealth presented adequate evidence for the fact finder to find the defendant guilty beyond a reasonable doubt on all 3 challenge charges. As the court has noted, the most critical moment in our analysis of the assault and battery charges is the moment at which Mary Holmes is pepper sprayed by the defendant. And I suggest to the court that this begins on Exhibit 5 at the 13:57:09 marker. That's the first pepper spray. The Commonwealth believes there's a second spray about 2 seconds later. That between
Did the pepper spray result in a conviction for the assault and battery?
Yes.
So once she's pepper sprayed, even assuming she felt wronged or that it was an illegal arrest, she continues to resist at that point. Is that provide the necessary reasonable force at that point the officer had to take to control her and place her under arrest? I mean, there was quite a struggle there between the one officer and ultimately the 2 officers and Ms. Holmes. Ms. Holmes, even though she felt maybe wrong, didn't she have some, she couldn't continue to resist even an illegal arrest at that point, and the officers had to continue to follow through, and it seemed as though until they could actually get her to the ground by whatever means, they weren't able to overcome her resistance. So is anything after the pepper spray alleged to be unreasonable?
Yes. At the moment of the pepper spray, because that use of force is excessive and unreasonable, there's no further justification of the defendant's use of force, including the use of the baton. A police officer in this situation cannot use excessive force and then use additional excessive force and have that be justified by the resistance of the civilian. In the resisting arrest jury instruction, it says that a civilian may not physically resist arrest, lawful or unlawful arrest, except when excessive and unreasonable force has been used. And the struggle that begins after the pepper spray isn't a struggle initiated by Mary Holmes. And all of this, these reasonable inferences were before the fact finder in this case who convicted the defendant on these grounds of assault and battery. The physical struggle that begins after the pepper spray is initiated and continued by the defendant. And
so you're saying at one course, once the initial unreasonable force of the pepper spray, there's any continued force is considered unreasonable.
Yes.
Was Ms. Holmes ever informed at the scene that she was actually being arrested? It seemed to me she was a little surprised when she was at the booking station that they were even processing her. She didn't understand that she was being arrested.
That's correct. The evidence before the fact finder, again, in the light most favorable to the Commonwealth, was that she was never informed that she was under arrest. She was given instructions to back up, which she complied with. She was never, the words arrest were never used, and she was never given explicit notice.
The words those specific words don't need to be used. I think the point, if I understand what you're trying to argue, is that based on what the trial judge had available, he was able to reach the conclusion, supported by the evidence, that a reasonable person in Ms. Holmes' situation would not have understood that she was being placed under arrest.
That's correct.
Okay, and just to go back to another point, is it your contention that that once excessive force is used by the police, that the person that they are placing under arrest or attempting to place under arrest by use of excessive force, that person may respond using any amount of force, or are there limits on the force that the arrestee may use in response to the excessive force?
There are limits on the amount of force that may be used to resist an arrest, and I'd point the court towards the model jury instruction 9.26 subsection 12 that says, if a police officer uses excessive or unnecessary force to make an arrest, whether the arrest is legal or illegal, the person who is being arrested may defend himself with as much force as reasonably appears to be necessary. And they must stop resisting once it's made clear that when they stop, the police officer will also stop with the unnecessary force. And in this case, the Commonwealth contests that there was any, or I'll rephrase that before the fact finder was adequate evidence that there was no reason to arrest Mary Holmes. And even if there was reason to arrest her, the force used to arrest her was unreasonable because, as the court has noted already during argument, at the time of the pepper spray, she has cooperated with the police officer's commands. As you can hear from the audio overlay on Exhibit 5, she has connected with 911. She's verbally acknowledging her compliance. And she is pepper sprayed despite that, despite having been moved away from the scene of the police interaction with Ms. Williams, being further away than many bystanders, and cooperating with the officer at that time.
Just to be clear, my understanding is that the 2 counts of assault and battery were based first, as you said, on the pepper spray, and second with the baton strikes?
That's correct. If the court has no further questions about the assault and battery charges, I'll move to the filing a false incident report. Again, as the court has noted, the video evidence in this case is clear. And what's important about this incident report is the moments at which the defendant deliberately includes falsehoods into the narratives. And she includes those falsehoods at the moments that are necessary to justify her use of force and her actions against Ms. Holmes, which clearly show her intentional inclusion of those facts and the knowledge that they were material facts at those moments in the incident report. Lastly, I'll say that the defendant was not deprived of any meaningful opportunity to cross-examine Officer Trin. The 2 questions for which objections were sustained do not show a court curtailing a defense attorney's ability or opportunity to cross-examine. The choice not to pursue further questions was simply a choice of the defense attorney, but not an order of the court. If there are no further questions, I will rest on my brief.
Seeing none, thank you both.
We are live and on the record.
The next case on our hearing list this morning is case number 2019 P1232, the Commonwealth versus Adrian M. Garcia. We will be taking a brief recess of about 15 minutes at the conclusion of the argument in this case. But for now, Ms. Daly, you may proceed for the defendant.
Thank you, Your Honors, and may it please the court. Rosemary Daly for Mr. Garcia. Your Honors, long before Miranda, it was held that a defendant who is in custody has a right to remain silent. The rule is so fundamental that it requires little elaboration. In fact, the government, on page 16 of its brief, has conceded that comments on silence, including refusing to answer booking questions, should not be commented on trial. That Mr. Garcia's post-arrest silence was in response to booking questions about his employment status magnified the risk in this case. Particularly, whereas here, Mr. Garcia was arrested on drug charges and possessed what might be considered to be an untypical amount of cash at the time of his arrest. This error, as well as the lack of evidence of intent to distribute the 15 fentanyl pills, are what brings us to court today. Your Honor, turning first to the comments on silence. Here, during the course of booking, the booking officer asked Mr. Garcia the standard but series of booking questions: his name, address, date of birth, social security, occupation, as best he could, because in the officer's opinion, Mr. Garcia's behavior was erratic. He then asked, did you try to ask Mr. Garcia the question about whether or not he went to school, was employed? Yes. Did you get an answer? The officer answered, no, I didn't. At this point, the prosecutor now honed in on the employment question and asked, okay, so he did not affirmatively tell you he had a job? No, he was all over the place. I would ask a certain question. At this point, defense counsel objected and the objection was overruled.
Are you suggesting that objection at that time is sufficient to preserve the question of whether he was asked whether he was employed? Shouldn't have been made earlier to preserve that?
Well, Your Honor, in the beginning, it was a little bit unclear. It went to schooling or whether or not he was employed. At that point, the prosecutor then really honed in and said, okay, so he didn't affirmatively tell you he had a job? At that point, it should be considered definitely for harmless error.
And there was no objection to that?
There was an objection right immediately after that, Your Honor.
Well, not to the question.
Did you get an answer? No. Okay, so he did not affirmatively tell you he had a job? No. He was all over the place. I would ask a certain question. Objection overruled.
So it sounds like the objection was to the answer.
Well, Your Honor, at this point, you know, obviously the defendant's position would be it was to the comment on silence, which was a reasonable inference from what was said here. It was clearly going to a silence. Why was he talking about having a job or whether or not he was employed? That was the harmful comment. But even under a substantial risk standard, it was certainly inappropriate.
And where is it indicated that he was silent?
He said he didn't answer. Okay, so he did not affirmatively tell you he had a job? No. He was all over the place. I would ask a certain question. Objection overruled.
That indicates it was silence? I'm sorry.
No, that's all right.
Justice Desmond, I'm sorry, I didn't hear your question.
I didn't mean to speak over Justice Lemire. My question was going to be, what are we to take from he was all over the place? Doesn't that infer that he was commenting or saying something?
Well, Your Honor, at this point, I think it was a reasonable inference for the jury to assume that he didn't answer the employment question.
Directly.
Earlier, he was talking.
But directly, but that doesn't mean he was silent, right?
Well, Your Honor, I would say he refused to answer that question at the very least. He didn't answer that question. That's the very least and the most favorable to the government you can get out of this.
Provided a response, but it was a non-responsive response.
At the very least. At the very least.
But even if he was all over the place, is not silence. Right?
Well, all over the place, I think earlier on, when you read it in context, Mr. Garcia, they were talking about how erratic he was. He was moving around, that kind of thing. So his behavior was erratic. But I think the way they honed in on this particular question, which wasn't necessary, you could have simply left it at the defendant was behaving erratically. He wasn't responsive or whatever, he wasn't responsive, he was behaving erratically and moving around. That would have been fine. But what was the purpose of asking this question? When it usually comes up, it comes up in the context of OUI cases, like in the Gonzalez case or in Ayers, where they were trying to suggest that the defendant's behavior was belligerent or that he wasn't responsive, is somehow indicative of his level of intoxication. Here we don't have that same thing at all. The harm here came because it is a drug case, and he had drugs on his person and not on his person. He was charged with possession of drugs, and he had cash on his person. So the harm here was whether the jury would have been left with the inference that he was unemployed. and that might be the source of the funds that he had on his person. So even under a substantial risk standard, it was different. If we look now at the Gonzalez case, or
while we're on that point, did the prosecutor return to that element of the evidence in closing?
No, they did not. So there was no mention again in closing. So here, when we look at the Ayers case, what we had is it was booking questions in the context of an OUI case. But in that particular case, the defendant wasn't answering any questions. Here, at least from what we can glean from the transcript, Mr. Garcia did answer some questions. And when it came to the booking questions, he was either not responsive or did not answer them. So the booking questions concerning employment, he either was not responsive or did not answer that particular question. And as the court is well aware, when we're dealing with drug cases and booking questions, this is really an area of concern because of the very fact that the jury might have been left with the impression that Mr. Garcia was not employed when that indeed may not have been the case at all.
Now that issue wasn't argued or brought up again, if I read the transcript correctly.
Yes, Your Honor, it was not mentioned in the closing at all.
So there was that one series of questions about him answering whether he was employed, and the officer's response was kind of rambling at one point that he was going on about doing his own thing and basically indicating he was erratic. And that was the extent of that question. And your position is just asking that question is sufficient prejudicial harm to reverse?
Yes, Your Honor, but even under a substantial risk standard, when it's considered with the really insufficient evidence of intent to distribute the fentanyl pills, that really, like in Gonzalez, that's what happened there. It was the combination of errors that resulted in a reversal in that particular case.
Wasn't testimony directed to the intent to distribute from one of the officers?
I'm sorry, Your Honor, I didn't catch the first part of your question.
Wasn't there testimony by one of the officers at trial directed to the intent to distribute?
Your Honor, what we had an intent to distribute, yes, there was an expert that that the government called, an Officer Feeney, who talked about the drug distribution patterns, et cetera.
If based on that expert opinion, if that opinion is given credit by the jury, doesn't that foreclose your argument on sufficiency?
No, Your Honor, not vis-a-vis the fentanyl charge, because with the fentanyl intent to distribute, it was clearly different than the cocaine.
I understand that, but I thought that there was testimony specifically directed to the fentanyl.
The testimony that went to the fentanyl was very, very scant. All we had there was the Officer Feeney, who testified that sometimes fentanyl is found cut with other drugs, and other times when it's alone is almost in pure form in a white powder. He then switched to talking about oxycodone pills. In this particular case, the fentanyl had been marked as oxycodone 30 milligrams, but it was not oxycodone. There was no testimony about the packaging, purchasing patterns, or cost of fentanyl pills. There was no evidence of the strength of the particular fentanyl pills or the dosage of fentanyl pills that would be consistent here. There was no evidence of the street value. His testimony really added nothing to the fact other than that there were 15 fentanyl pills marked as oxycodone pills.
But we know that the fentanyl pills, one, were disguised or marked as oxycodone. They weren't marked as fentanyl. That's
correct, Your Honor.
One factor. We know that the fentanyl pills were kept in the same location as the cocaine. They were all bundled together, correct? We know that.
They were in separate bags in the same package.
In the same package. We know that he offered the waitress to leave her tip in cocaine or in cash. We know that.
Correct, Your Honor.
And so the cocaine being coupled with the fentanyl pills and the fentanyl pills being marked in something other than fentanyl, can't the jury infer that all of that was for possible distribution? Just on those facts alone?
Well, Your Honor, not necessarily.
Not necessarily.
Correct.
Because
I think they're left with speculation. It could have gone one way or the other. Here,
let me add one more factual element to the inventory that Justice Desmond has provided, because I think there was testimony that oxycodone pills, at least, are marketed as single pills, are sold as single pills in this manner, right?
yes, Your Honor, that
The fact that
typically,
this was marked as oxycodone, would it be rational for a fact finder to infer that something marked as oxycodone was being marketed and sold in the manner that one who was engaged in drug distribution would market and sell oxycodone?
Your Honor, not necessarily. I understand the court's point. I understand exactly what you're saying, but here,
well, but you're also familiar, I think, as we all are, with the phrasing from Lattimore itself that says that the inferences need not be necessary. So when you say not necessarily, it carries us back into that very, very rich vein of sufficiency.
well, I think what we're doing, I understand the Lattimore standard, and I think what's happening here is we're having inference on inferences. He was not charged with a counterfeit drug or anything to do with oxy. And again, as this court is well aware, fentanyl is a fairly new to the market kind of drug. It's not within the average ken of a juror to know how much is consistent with possession with intent to distribute. We had 15 fentanyl pills. And there are cases, I believe it's the Ellis case, that said a large amount of one drug, if it's the cocaine, is not necessarily, doesn't transfer over to an intent to distribute a smaller amount of drugs. That was cited in my brief. So I think the thing here is, would your average juror know 15 fentanyl pills of an unknown strength? Would they be consistent with an intent to distribute rather than with personal use?
Well, when they're set up as an oxycodone pill that is being marketed as sold in pills, separate pills, and there's 15 of them, the fact that it's fentanyl inside, it's being marketed as another drug, it's still being sold theoretically if the jury accepts that those pills were there for the purpose of being sold. They contained fentanyl, but were marked as oxycodone. It doesn't mean that the fentanyl wasn't there for possession with intent to distribute. It was covered as oxycodone.
I understand exactly what the court is saying, but here, unlike with the cocaine, where we did have the comment about whether the waitress would like her tip in cocaine or cash, we had no such comments here. We had nothing to suggest that it was anything other really than that he might have used it for his own personal use.
We had his comment as he was being escorted out of the establishment that he was affiliated with a cartel.
He did make that comment, Your Honor, but again, he was acting erratically at the time and very, very upset because he didn't believe he was being fairly escorted out of the establishment.
And that he had no fingerprints.
Yes, he did say that.
Before your time is up, your third argument, I believe it's whether the synergistic effect of the booking officer's comments require reversal under the substantial risk standard. I apologize. I don't quite understand what the nature of that argument is. Is it different from your first argument about Go ahead.
Sorry.
Go ahead. I'd like an answer.
Okay. Yes, Your Honor, because in Gonsalves and some of the other cases where this kind of comment arose in the context of employment questions, where they didn't reverse on a harmless error standard, they did reverse into substantial risk because that error, together with the other errors in the case, were enough to tip the scale in terms of reversal. So really under substantial risk, that's what happened in Gonsalves.
So when you say synergistic, you mean as regarding any other errors?
Yes, the whole thing, the cumulative effect, if you will.
Thank you.
If there are no further questions, Your Honor, I see that my time has expired.
Thank you. For the Commonwealth.
Good morning, Your Honors. May it please the court. Erin Knight on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I want to just briefly start with the standard of review for the officer's testimony. I do think that Your Honor's thinking regarding where the objection was placed is correct, that this would be under a substantial risk standard. What is clear from the line of questioning and the objection both during this spot of the testimony, as well as just before Officer Almeida's testimony during Officer Maloney's testimony, there was another objection. It went towards the demeanor and the behavior, the erratic behavior of the defendant. And I do believe that's what the defense counsel was trying to object to here. He did not object to the question itself, which would have been the proper point for the objection. Instead, he objected after the officer started to go into the defendant's erratic behavior again. In terms of that erratic behavior, that's what the prosecutor was trying to get at. In her opening, she explained that the jury would be able to listen to testimony regarding his erratic behavior that night, both at the restaurant and again at booking. And at booking, his behavior was uncooperative. He would not physically comply with commands. He kept moving his hands during fingerprinting. And the testimony of Officer Almeida that he did not respond to the employment and schooling question was just in furtherance of the fact that he was not cooperating. And that is testimony that is proper in the Commonwealth, even after the objection, the testimony continued about the defendant's behavior. And I think that it's clear that that was what was trying to be elicited. And in any event, the testimony of Officer Almeida regarding that he did not get a response to that question was the only time that that was brought up. As my sister had mentioned, it was never brought up again in further testimony or in the prosecutor's closing. So I do believe that where the evidence against him here was very strong, you had the waitress that testified that he offered to pay her in cocaine. The waitress saw the unorganized wad of cash that later ended up being $1,300 in cash. When he was escorted out of the restaurant, he yelled that he was in a cartel. He also yelled that he didn't have any fingerprints. He was just behaving very erratically. Multiple civilian witnesses, uninterested civilian witnesses, testified that they saw him throw the block of cocaine and fentanyl pills together under the van. One of the restaurant employees stood by that van till police were able to recover exactly where he threw it. And then you have Sergeant Detective Feeney's expert testimony regarding the amount and the intent to distribute here.
At one point when that was going on, wasn't the employee videotaping the defendant?
Yes, Your Honor, and I do believe that there's testimony regarding the actual drop of the drugs was not caught on video, or the video had not transferred from his phone, but there was video submitted to the jury that they could see his erratic behavior. The defendant actually ended up calling the police himself. That's why police arrived on scene. And when the police showed up, he actually confronted them himself. So there was a plethora of evidence, despite the testimony of Officer Almeida regarding the non-response to the employment question, that would lead the jury to consider intent to distribute and to convict him on those charges.
I don't think it was wrong, but does the erratic behavior gain anything in a distribution or possession with intent to distribute case? I mean,
I think, Your Honor, I think it goes to his behavior, his uncooperativeness, the fact that he was saying that the drugs were not his. It also goes to allow more in-depth review of his comments, that he's in a cartel, that he doesn't have fingerprints, just in context of how the entire night was going. Again, he offered to pay his waitress in cocaine. There was just a lot going on that I think was proper for the jury to consider in the full context.
Some of his erratic behavior could be used by a savvy defense attorney to suggest that he was using, not distributing.
Absolutely, Your Honor. There was evidence that his nose was running, his eyes were bloodshot, but at the same time, the jury had all of that in front of them, and under the Lattimore standard, they can consider everything in the light. We consider everything in the light most favorable to the Commonwealth, and there was certainly enough evidence here to find him guilty of intent to distribute both the fentanyl and the cocaine.
And of course, it's possible to be both using and distributing anyway.
Absolutely, Your Honor. If there are no further questions, the Commonwealth would rest on its brief.
Thank you both. We will take a brief recess and resume at 11:05.
with prejudice, then a new trial is warranted. I spent some time this morning going through the last time the court flipped a case based solely on closing arguments, and candidly, it is quite some time ago.
Mr. HENRIQUE was acquitted of one charge. Is that right, sir?
He was, Your Honor. He was. But I would suggest to the court that the mere fact he was acquitted on one charge does not alleviate the Commonwealth from their obligation to present a fair and appropriate closing argument in this case. And there can be no doubt whatsoever that this closing argument was riddled from top to bottom with improper argument. Specifically, and when I reviewed my brief, I must admit, I think I gave it somewhat short shrift in my brief. The most important thing I would suggest to the court is not only did the Commonwealth give improper argument as far as those statements concerning what a sexual assault victim looked like, but the thing I gave short shrift to was the Commonwealth was specifically told by the trial court that they may not argue this specific point. There was an objection during the examination of the witness when there was testimony regarding the specific incident. And then in the second volume of the transcripts on pages 166 to 168, the judge went out of her way to say, unless you have an expert witness to tie in your questioning right now, I'm not going to let you continue this line of questioning, and I'm not going to let you argue it during closings. So it wasn't just that the Commonwealth was arguing something that they shouldn't have argued regardless, but they'd specifically been told by the judge that this is not something they can argue, and they ignored it. And this factor had nothing to do with whether or not the victim should be believed. This factor had nothing to do with the credibility contest between the defendant's case and the Commonwealth's case. This was just something that shouldn't have come in. And with all due respect to the Commonwealth, in their brief, they really do soft sell these errors. And the fact of the matter is that this was a credibility contest from beginning to end. And in their closing argument, the Commonwealth put their thumb on the scale. And that's just wrong. It's not allowed.
Did the judge provide a very forceful curative instruction immediately following the Commonwealth's closing?
I don't think the judge gave a strong curative instruction at all, with one exception. And the Commonwealth goes on in their brief about this to some extent. There were some other improper statements, and I dropped them in a footnote in my brief. There were some improper statements that the judge specifically addressed. The statements along the lines of, you should believe I'm paraphrasing, you should believe the victim because she came in and testified, and therefore you should believe her. Defense counsel objected, and the judge gave a specific instruction that that's not allowed under the law, and that they are to not consider that in their deliberation. And I don't mention it because the judge got it right. The judge gave a specific argument, a specific curative instruction about this point. So the judge knows how to give a curative instruction. Obviously, the judge did it. But for these other issues that I would suggest are so pernicious and so fraught with
well, I mean, I have to say it's that in a credibility contest, it's that credibility argument that struck me as being the most egregious of the errors. So since we're in agreement that the curative instruction adequately addressed that misstatement, I would like it if you could help me by walking through with a little bit more targeted fashion rather than talking about pervasive and riddled and everything else. Walk me through what the errors are that require a new trial.
The Commonwealth says in their closing at page 67 in volume 3, they argue exactly what the judge said had to be kept out, that the actions of the victim were, quote, consistent with someone who had just been molested. And that was something they were prohibited from doing during their case. They were prohibited from asking the victim about. The judge specifically told them they cannot do it, and nevertheless, there it comes out in the closing argument.
Apart from the fact that the judge had said you can't do that, I mean, why isn't that kind of a statement encompassed by the standard instruction that the arguments of the attorneys are not evidence? There was no evidence on that point, right?
There was no evidence whatsoever. That evidence was excluded.
Right. So when the judge instructs the jury that you're not to consider anything that is said by way of argument that's not supported by the evidence, why is that not doesn't that address it?
My concern is this. That is a standard argument that's given in almost every case that's an instruction that's given in almost every case where there's a closing argument. It's not tailored to specific cases. It's literally in the judge's handbook of instructions to give to the jury.
Sure it is, but the jurors are hearing it and they're taking every word in those instructions to heart because it's not as routine to them as it is to you and me.
I would suggest, Your Honor, the problem is this, is that if we allow that instruction to erase any error ever made by the Commonwealth during the closing argument, they may as well open up the door to closing arguments.
I understand that, but we're not, that's not what's in front of us. We have this this single, look, I can feel your outrage about the fact that the prosecutor went ahead and did something that they had been specifically admonished against doing. But that does not bear on the impact of that statement in the closing argument on the jury, does it?
The fact that the Commonwealth was told that they shouldn't do it?
Right.
No, I don't think that impacts the statement on the jury, but
so
I think it
we have then is when the Commonwealth argues facts not in evidence, and the jury are told don't consider arguments as evidence. The question then is, in the circumstances of this case, was that statement so impactful that we must order a new trial?
I think that if that had been the only error that had
let's go on to the next one.
And in the next one, where the district attorney, now the prosecutor isn't just providing evidence to the court. In the next statement, where he characterizes the defendant's actions as grooming behavior, now he's not just providing facts on evidence. Now he's interpreting that evidence for the jury.
Isn't that a fair inference?
I'm sorry.
Isn't it a fair inference that he indeed was grooming her? He was buying her dirt bikes or taking her out on rides. He was favoring her, it appeared. I mean, wasn't that a reasonable inference?
I don't believe so, Your Honor, because again, the statement is tied to not just that he was grooming the victim in this case, but his ultimate desire, which was to have sex. And there was no evidence whatsoever. So again, he's taking the defendant's words. He's taking the testimony from the case. He's not just providing facts on evidence. He's interpreting it and then he's extrapolating it. And I suggest he's going far beyond what the normal course of argument would be. Obviously,
let me ask you, I'm going to interrupt you for 1 second. Was there any motion to strike any portion of the closing argument?
There were objections made during the course of the closing argument.
Was there any motions to strike? Were there any motions to strike any portions of the closing argument?
I don't believe I don't believe that verbiage was used. I know that.
Were there any special curative instructions requested?
At the end of the closing argument, when there's a sidebar with the judge, and I want to say it's on page 83 of the third volume. At that point, one of the focuses, the main focus of defense counsel seems to be the absolutely improper statement of believing the witness because she came here and testified for you. So defense counsel, and there's an overlap in the transcript where defense counsel is trying to make his objections. The prosecutor is somewhat trying to explain them away. The judges is talking about how that specific thing, the thing that the Chief Justice was just talking about, how that's completely improper. And defense counsel is trying to, I think he asked for a mistrial. He's asking for things. So I want to say that I want to be able to say yes or no, Your Honor. But I think if you read the overlapping arguments that happen, I believe it's page 83. I'm going to say yes, but with an asterisk that it's somewhat lost in the scrum, if you will.
Okay. Thank you.
So again, just to pick up where I left off, we have these statements that are made. They're improper. There is I would suggest a boilerplate instruction that, as Chief Justice Green knows, I'm channeling my inner Justice Brown. At what point do we say to the Commonwealth, we've done this in hundreds of cases. We've said it's improper. We've said you shouldn't do it. We've talked about the fact that there's a boilerplate instruction. and we've never crossed that line. And I'm suggesting to the court, this is it. At what point do we hold the Commonwealth accountable for violating the rules that we all know? The Commonwealth says in their brief, these are improper statements. They acknowledge that the statements made in closing were wrong. They acknowledge that when you have a rape victim, or a sexual assault victim, you can't say that, look at these things she did. This is indicative. I, the Commonwealth, cloaked in the authority of the Commonwealth of Massachusetts, am saying to you, of course that's the behavior of a rape victim. I suggest to you that that's grooming. Good for you, ladies and gentlemen of the jury, that we're interceding before it led to sex. And then there's more. And then there's some statements that weren't objected to. But again, the evidence in this case was far from overwhelming. There's no forensics. There's statements made. The alleged victim changes her testimony. At one point, she gives contradicting statements. The most serious allegations she omits when she sits down for her SANE interview. So this is literally a credibility contest between these folks. And the Commonwealth, as I said before, they're putting their thumb on the scale. And I would suggest to you, at some point, we have to say enough. At some point, it's incumbent upon this court, with all due respect, to say, we've given the rules to the Commonwealth so many times. And at some point, we have to say, you've now violated the rule for the 900th time in closing argument cases in our jurisprudence. And we have to reverse a case. And I don't know why this isn't that case.
So we need to make an example of the Commonwealth in this case. Is that what I hear you saying?
I don't need an example of the Commonwealth in the case. I think the Commonwealth has made examples of in dozens of cases before, but maybe this one should push us over the goal line. Again, the evidence wasn't overwhelming. It's a district court case. The alleged victim leaves out the most serious allegations in her interview with the police and during the SANE interview. And I would submit to the court is unable to really explain it away during direct or cross-examination. The judge gives an instruction that wholly lacks teeth, and this is that case. Commonwealth v. Alvarez, it clearly states that issues surrounding what a sexual assault victim may do or not do is a very complicated issue. Commonwealth v. Miller, which is a case that's cited in my brief, and it's put in my appendix because it's unpublished. It's directly on point. It's practically the same language. These are real issues. And despite the fact that there are case after case after case, the Commonwealth seems to keep getting away with it. They are acknowledging in their brief today that these statements were inappropriate, that these statements were wrong. They spend a great deal of time, I would suggest to the court, talking about the statement that the judge got right, the statement that was objected to, and the judge got right. The Commonwealth seems to say in their brief that there are opportunities to talk about the characteristics of sexual assault victims. And therefore, this evidence or these statements from the Commonwealth during closings were fine. But this isn't that case. If there'd been an expert witness with full disclosure and the ability to talk about that, different story entirely. But just because this evidence could have come in under a different case doesn't mean in this case that they should be able to get away with it. And I suppose, Justice Desmond, I suppose you're right. I suppose I am suggesting that at some point we hold the Commonwealth accountable and that we make an example of them. And I can't think of a better case than this one, given the facts and circumstances surrounding the incident, the facts and circumstances surrounding the disclosure, the statements made by the complaining witness during her SANE interview and to the police officers. This is the case. And I say that with all due respect to the complaining witness in this matter. This is the case. We have to hold the Commonwealth's feet to the fire. Otherwise, every single time the Commonwealth wants to say whatever they want in a closing argument, we just keep winking and nodding. And I say this with all due respect to the court, but at some point, we have to take a stand. And I would suggest to you this is that case. If there are no further questions, I'll simply rely upon my brief.
Thank you. Thank you. For the Commonwealth.
Thank you. If it may please the court, Elizabeth Mello for the Commonwealth. Your Honors, as you saw from the brief, there were mistakes made. There were statements that perhaps could have been worded differently or perhaps not said at all. I can't speak to hundreds of other cases. We're talking about this particular case. And in looking at this trial, looking at a closing argument that spanned about 17 pages of transcript, a 2-day trial with 7 witnesses, The trial judge was there to hear every single word said by both attorneys, gave preliminary instructions, gave a curative instruction, gave final instructions, which, by the way, defense counsel did not ask for any additional instructions. He was content with the instructions, the curative and the final. And the jury took those instructions seriously. And how do we know that? Because they didn't just leave for 20 minutes and come back with guilty on all counts. They were out for about 3 hours. They asked questions. They asked if they could review one of the testimony of one of the witnesses, which the court told them they didn't have the capability to do that. And they took the time to listen and rewatch the complaining witness's SANE interview before coming back a little over 3 hours, coming back with an acquittal on one of the counts, guilty on 2 of the counts. So clearly they didn't just wholeheartedly believe the complaining witness. Presumably they didn't when they came back with a not guilty on one of the counts. Were there statements, as I mentioned, that perhaps should not have been worded in quite that way? Yes. However, if you look at the entire closing argument, the prosecutor was trying to lay out to the jury an explanation for some of those inconsistencies.
This was more than that, in fairness, wasn't it? I mean, this was a bad argument.
At times it was.
And it's not just a matter of an inapt choice of words. And so the question is, as among the improper statements made by the prosecutor, which were preserved, which were unpreserved, and what is the impact? These cases, of course, are those where the potential for an error has the greatest potential. The potential prejudice from an error is the greatest because it's all a test of credibility in the absence of forensics, right?
Correct, Your Honor.
So, when the prosecutor engages in improper arguments, unless we're satisfied that it doesn't have an impact on the way the jury weighs the evidence, we can't just look the other way, right?
Correct. And the Commonwealth is not suggesting you should just look the other way. What the Commonwealth is suggesting is, yes, there were errors made, but looking at the entire argument and looking at the judge's response. Basically, there were 4 complained of in this instance, 4 complained of statements, 2 that were objected to at the time, which was the statement in regards to believe the victim, which that did have
what I call the Hellberg error, Hellberg-Beaudry on credibility because they came to court to testify. Correct.
That was given a curative instruction, and
we're agreed that's not at the center of the defendant's
correct. Correct. Then the next complained of was the statement in regards to the complaining witness's behavior being consistent with someone who had been molested. That is true. The Commonwealth was specifically instructed that unless they were bringing in an expert, they would not be able to speak to things like her sleeping patterns or changes in her grades or any of that type of thing. And while in closing argument, the prosecutor made that comment about consistent with someone being molested, that was not a statement that should be made, that it agreed to, that was objected to. However, that was in the context of witnesses that were being allowed to testify in general to her demeanor on the day of one of the incidents and at the time of disclosure. When that's testimony that is admissible and is proper in closing argument to then reference.
You can reference it, but you can't interpret it in that manner. And the prosecutor took it to just exactly the place that it should not have been taken.
He did.
And there was no evidence that he was necessarily grooming her for sex, so to speak. And he attacks that. I mean, you say that they were out for 3 hours and, they reviewed this evidence and they came back with 1 acquittal. Well, your brother would argue, had the government stayed within bounds, they would have been out for 20 minutes and came back with 3 acquittals. And so that's the prejudice that he says happened as a result of the cumulative effect of all of these missteps. What's your direct response to that?
Correct. I don't think that any of us have a crystal ball that can accurately say what was in the mind of the jury. All we can look at as is what happened on that day. And that's what happened on that day. And the judge who gave these instructions, the curative, the final, the preliminary, she was there for the entire thing. She gave these instructions, which again, as Chief Justice pointed out, this is not everyday common language for the jurors. These are not instructions that they hear every day. And to just say that it doesn't matter that they heard these instructions, well, it renders all instructions from all judges basically pointless, meaningless, if we're going to say it doesn't matter what the judge says, that we're going to assume that juries are not following it. Actually, we assume the opposite. We presume that they took those instructions, that they followed them. The instructions were given, they were forceful, no additional instructions were requested, and the jury then took the case. In this matter, the Commonwealth, again, concedes, not denying that there were statements that should not have been made. That's not even what we're talking about here. What we're talking about here from a Commonwealth point of view is, were those misstatements given the judge's curative instruction and general instructions? Were they so egregious that the verdict needs to be thrown out? And from the Commonwealth's position, the answer to that question would be no, because the judge gave proper instructions before, curative, and final.
To follow Mr. Corman's reference to my friend and former colleague, Justice Brown, what is the Commonwealth doing to try to prevent this sort of improper argument from taking place?
Well, I can't speak obviously for every office every DA's office in the Commonwealth, but
let's limit it, of course, to your office.
In my experience in these types of situations, then there's additional training. It's pulling prosecutors aside. It's reviewing transcripts of closing arguments. It's talking about
But this is around the bend, really. I mean, when a prosecutor says is told specifically to stay away from a particular topic, and goes directly to that topic. The Hellberg error, that's boilerplate. I mean, so this is not that the response to that shouldn't be when they do something wrong, we're going to take remedial action. Don't you do some kind of a training program at the beginning?
Yes, Your Honor, there is. I thought the question was what happens when these mistakes are brought to light.
No. My question is, but they still go on. So and this is where I won't do it the same way that Justice Brown did, but the inquiry is sincere. My question is, what can you do to because we keep getting these cases? Mm-hmm. What can you do to stop the flow?
Well, clearly there has to be more work done on the front end as prosecutors are hired and trained.
I think Justice Brown probably included an inventory and a footnote to one of his latter day opinions that talked about the number of times that we've said just exactly that, and yet.
Understood, Your Honor. I can't answer any more eloquently than that, quite frankly. Again, they were statements that shouldn't have been made, and I can't say anything else about that. Why this particular prosecutor made those statements, I can't explain that either. Again, looking at the entire argument, they were statements a line, crossing that line, a line too far, so to speak. But again, in looking at whether or not it should be reversed, is going back to the entire argument and the trial judge's curative instruction and final instruction. And there was a motion for a mistrial at the close of this, and she denied that. So given everything that the trial judge heard, saw, said herself, and intervened, she did not feel that it rose to that level. And she was in the best position to assess everything that happened in that particular trial. So if the Commonwealth would rest, if there are no further questions and no other comments to be made in regards to what happened, then the Commonwealth would rest on its brief.
Seeing none,
We are live and on the record.
the next case on our list for hearing this morning is case number 2020P285. This is a case involving the termination of parental rights, and again, it is impounded. For the mother, Ms. Kaiser, you may begin.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant mother. I'm going to focus my argument on the same position that the mother presented at trial, and that is whether there was clear and convincing evidence to show that the relationship between the mother and her daughter should be legally and permanently severed, or whether there should be a second attempt at family therapy before that drastic step was taken. And I would like the court to keep in mind 2 points. First, whatever the mother's deficits, the evidence was undisputed that she plays an important role, and in the words of the DCF expert, an irreplaceable role in the child's life. And second, that the lack of a visitation order, instead placing complete authority to determine whether visits would occur in the hands of the adoptive parents, left open the possibility that all contact would be terminated, and that would be to the child's detriment. So
although the adoptive parents have articulated their willingness to have mom come visit and have sibling visitation as well, isn't that right?
Well, there is an order for sibling visitation, but with regard to whether the adoptive parents were willing to facilitate visits between the mother and the child, that's a lot less unclear. There was very little evidence, actually one sentence in a 1,500-page transcript with regard to what the pre-adoptive parents thought about post-adoption visitation. And that's that, in the words of the adoption worker, that they agreed that visits or contact with the birth family would be important. That is insufficient to guarantee that the pre-adoptive parents would continue to allow the mother to be involved in the child's life. And in fact, the court made no findings in that regard and didn't really specify anything in that regard in its order. And it really couldn't have, because it had such a small amount of evidence before it. But I would also call the court's attention to the fact that the trial court had before it substantial evidence that the pre-adoptive parents had a distorted view of the mother. There were, in the court investigators' reports, reprinted diaries from the foster parents at that time that blamed every bit of misbehavior or difficulty on the part of the child and the child's brother when he happened to be placed in the same foster home on the child's visits with the mother. And in addition, those diaries seemed unable to separate real concerns from the trivial. So, it was in fact, legitimate for them to be concerned about certain aspects of the mother's behavior. But on the other hand, they also wrote about being very upset that the visit supervisor lost sight of the mother and the children when they were on paddle boats, and the paddle boats went around a bend, as if, there was some real concern something terrible would happen during that minute that the paddle boats were out of sight. There was also evidence in these diaries that the foster father compared the mother to a terrible case in New Mexico where the child had been killed. There is nothing that was ever presented with regard to the mother that suggested that she would be violent or physically abusive in any way to either of her children. And the court did not take into account this view that the foster parents appeared to have of the mother when deciding that visits should be totally at their discretion.
Was there evidence that the mother, and I might be mistaken, but was there evidence that the mother had struck the child with a spatula in the face?
Your Honor, I am not recalling anything like. There may have been an allegation at one point. As you know, it's a voluminous record, but if there was such evidence, it was an isolated incident. As you're aware, the primary allegations had to do with the failure of the mother to protect the child from sexual abuse. The case revolved around, not allegations of physical abuse. So in terms of the law on post-adoption visitation, adoption of RICO makes it clear that when the child's best interests require, the trial court is not just entitled to issue a post-adoption visitation order, it's required to do so. Now, there is an exception set forth in Alona when you can be sure that the pre-adoptive parents will be acting in the child's best interest. But I would say that the trial court just didn't make findings on this matter and had evidence before it that the foster parents had a somewhat skewed vision of the mother, and very little evidence that they would promote such visits. And I think, you know, in terms of the child's interest, in some respects, a post-adoption visitation order would really help separate, you know, the worries about how the foster parents would react once they were adopted parents, and, you know, would have a clear and regular order that everyone could abide by that would, you know, promote some regularity and consistency in the visit order. And it is important to note that once this case is over and it's terminated, the child will not have counsel anymore. And the adoptive parents will be completely in charge. And in those circumstances, there really will be no recourse if the adoptive parents decide it's not in the child's interest to see the mother, and the child wants to see the mother, but, you know, she won't really, and the mother will be completely out of the case, and there'll be no real recourse. So I think at the very least, this case should be remanded for findings on post-adoption visitation. But in addition, there are issues with the termination itself, which of course has to be supported by clear and convincing evidence. I think here—
Mother concedes she's presently unfit, right?
Well, the mother at the time of trial said that her position was that she was currently unfit, and that return of the child to her care would not be feasible until there had been some family therapy. So really that was the focus of the trial, whether the mother's situation was so ongoing that that they would be unable to repair that relationship between the mother and the daughter through family therapy. And in that regard, I think that there was an error by the judge where he failed to consider all of the evidence. You know, a review of the evidence and the transcripts shows that there were really two portraits of the mother. The first is the one that was adopted by the trial judge and promoted by DCF, where, you know, the mother was hostile, she was uncooperative, made no progress, continued to make bad decisions. But there was a second portrait presented by the mother's service providers, which presented her as quite cooperative, having to deal with a very traumatic past of her own, but willing to work on issues, showing growth, showing commitment to her daughter. And I think at that point, with these two portraits, the court was required to determine which was accurate and should have noted the observations of neutral observers. And there were two successive court investigators, plus Dr. Rutherford, who did a neuropsych evaluation. And all of these parties, neutral parties, not taking a side in this case in any respect, were troubled by the conflict between the mother and DCF.
Ultimately, it's up to the trier of fact, the trial judge, to conduct the ultimate resolution of those conflicts, and the trial judge did that.
Well, it's of course up to the trial judge to make that judgment, but the findings should reflect that the judge considered all of the evidence, and I would say here the findings don't reflect that. For instance,
why? I mean, they don't have to inventory all of the evidence. And the mere fact that the portrait that the judge ultimately settled on is not the one that you wish he had doesn't mean that he didn't.
Well, I think, Your Honor, it's more than that. I think that the findings reflect a concentration on, the so-called bad facts about the mother and an exclusion of good facts about her. And adoption of Stewart says that, the findings have to reflect that the judge considered the so-called troublesome facts and factored those facts into the decision.
Well, didn't the judge say that there's no question about the fact that the mother and the child had a bond, and that there was no question about that mom had pretty much complied with her service plan and done all the things that she was asked to do? I think that's all in the record. The issue was whether or not she was learning from the compliance with the service plan. And I think that's kind of where the rubber hit the road for the judge, that they saw no marked improvement. The mother continued to coach the child to say no, that father hadn't molested the child, and they just didn't see any outward appearance of mother improving. And the child's now 12 years old.
Well, I think in that regard, so two things about that, Your Honor. First, it's exactly those things that you note. Number one, that the mother had complied with the service plan. And number two, that there was a very significant bond between the mother and the child that make it so important for the court to look at all the evidence here. And then in terms of, what the mother was doing at the time of trial, the mother's visits with the child had been supervised and for years. And the mother had been specifically instructed not to talk to the child about any of these incidents. So while there were allegations that in the past, the child had, or the mother, there were allegations that the mother had tried to coach the child, or that the mother had difficulty accepting some of the child's allegations. At the time of trial, it had been quite some time before the mother had even been alone with the child. And so I don't think it was an issue of the mother continuing to communicate to the child that she should deny the allegations. I think what the trial court found was that the mother, in its view, hadn't made sufficient progress because she didn't accept every single detail with regard to the child's allegations, and instead repeatedly testified, well, I don't know, I don't know that, and felt like she couldn't, she communicated that she couldn't endorse every detail of what the child said about her sexual abuse.
It was around when you say every effort to evade the allegations, right?
Excuse me?
It struck me as though it was a fairly persistent effort to evade acknowledging that history.
Well, I don't think that the evidence can be read that way, Your Honor, because the mother did definitely accept that the child had been sexually abused. She would not endorse, that the details of it. But, I believe that, kind of what happened in this case is that there was an over focus on the details of every single allegation because what the experts testified to was the important thing was for the mother to accept that the child had been sexually abused and to provide the child with support. And that was what family therapy was meant to accomplish.
But that it seems to me, in looking over this thing, on the whole, for the child's progress with the mother is probably the most troubling part, right? Because the child had the deeply rooted belief and understanding that the mother did not believe her. And that was, in terms of the progress that the child is going to need to make over the span of her lifetime from the trauma that she experienced, that may be the most important foundational factor of all, right?
Yes, but again, two things about that. First, the child, when asked, why do you think your mother doesn't believe you, said that other people had told her that. And because the mother's visits with the child had been supervised, it was not the mother saying that. And the second thing is that the mother's position was that family therapy should be tried. And that would have given a therapist the opportunity to meet with the mother, maybe for more than just one session, to really make sure that going into family therapy, that the mother was going to communicate to the child that she believed her, that that was the most important thing. And I think that that's where the courts needed to consider all of the evidence about the mother's behavior with her various service providers. Thank you.
Thank you. Okay, will the department or the child be going first?
The department.
Okay. You may proceed.
Thank you. Thank you, Your Honors. Good morning. It's Andrew Batchelor on behalf of the department. To respond briefly to some of the items raised earlier.
Mr. Batchelor, could you focus on this particular one? Isn't there record support that the mother called the child a liar and that believed that the child had continued struggles with telling the truth about some of the allegations that she was making?
Yes, the record is replete with mother's struggles in that. Mother refused to recognize the truth of child's allegations when the child made those allegations to mother. So back in 2014, when the child reported the allegations about father, when the child reported the allegations about the neighbor, both times the mother failed to believe the child. In fact, she went so far as to shake her head and discourage the child from speaking the truth about what happened, about what father did. She did that in front of DCF workers who informed the court of that. And mother continued to have an inability to accept the truth of the allegations long after that, and despite the courses she took and her parenting evaluation in 2015, that's finding of fact 51. Mother could not accept the truth of what happened then. In her statements to Ms. Webb in 2017, she again said that her daughter had been lying, and the court very carefully, although I agree with Justice Green, the court is not required to catalog every piece of evidence. The court did identify that Ms. Webb and mother had different memories of what happened at that meeting. And the court said that the court credited Miss Webb's version of that interaction, that mother had said child was lying. And even at the time of trial, mother could not say that she accepted the truth of what the child was saying. When the court directly asked her whether she had any idea whether her daughter, in mother's view, is lying or not, the mother said, "I don't know." She had no idea. And so it's just over the course of time, from the moment of the abuse up through trial, mother had a systematic inability to say that she believed the child, and there was no basis to hold out hope that the unfitness was only temporary. There's no reasonable belief that it was only temporary. And therefore, the detailed facts show by clear and convincing evidence that mother's unfitness was not temporary, and the court should be affirmed.
What do you say to the post-visitation or lack thereof?
I would say, Your Honor, that all of the facts given to you by Attorney Kaiser just now were also given to the trial court judge, and the trial court judge heard all of that, and finding of fact 149 found that the foster parents not only supported visitation, but said that visitation was critical. And so the trial court was in the best position to weigh the evidence, weigh the different testimony. And the trial court found that the foster family, the pre-adoptive family, did think visitation with mother and with brother were critical for child. Based on those facts, that the court's decision to not order child custody, child visitation, to respect the parental rights of the adoptive family is entirely in keeping with Ilona and was proper and should be affirmed. Also, very briefly, the court asked about a spatula, and that's in finding of fact 34. Justice Desmond. But I agree with Attorney Kaiser that that was not the motivating factor, if you will, of the trial court's decision here. And it's really that inability to understand, to address, to even begin to acknowledge the full scope of the abuse her child suffered that led, I believe, led the court to the conclusion it came to terminate parental rights. And the court was not focused on every single detail. In fact, as I went back through the transcript, I didn't see the court really pressing mother on any particular detail. The court just wanted to know if mother would accept that abuse happened by anyone other than the first babysitter, and mother couldn't. And it's gone over in detail in my brief, and so I won't repeat any of those points here. And unless there's any further questions from the court, I will rest on my brief.
Thank you. For the child?
I believe I still have the last few seconds to say good morning. My name is Alan Campbell. It's my privilege to represent, and I'll refer to my client as daughter in this matter. My client, the daughter, asks that this court affirm the judgment below in its entirety. I just have a few points to touch on. The first one is to address a point made by my sister that mother just couldn't accept all of the details of the allegations. And that really simply isn't the case. Mother couldn't accept the allegations. Mother had allowed 5 individuals to sexually abuse the daughter. Paternal grandfather or maternal step grandfather, father, 2 babysitters, and a neighbor. Only as to one of those allegations did mother indicate that she believed it. However, even as to that single one that she thought may have happened, she wasn't 100% certain. So there wasn't a single allegation that mother would say, yes, I believe this 100%. The case is, and I'm sure your honors have read through the records, the case is replete with instances of mother referring to the daughter as a liar. And during her testimony, she had a great phrase that she liked to use. I don't know that. She used that when asked whether she believed that the daughter had been sexually abused. She used that when she was asked whether she thought the daughter was a liar. She used that phrase when she was asked whether it would be helpful if she could stop calling the daughter a liar. I don't know. I don't know that. I don't know that. Mother, again, this isn't about the minutia. Mother simply could not accept that she had exposed daughter to at least 5 individuals who had sexually abused her. Mother did a great job of ticking off boxes on her action plans or service plans. However, she didn't benefit from it. At the time of trial, she was still unable to admit that she had put the child at risk. And that failure to admit it indicates that she would put the child at risk again if returned to her. As to the question of visitations, my brother did point out the finding. It's finding 149, where the judge found the foster parents, and I'm quoting, the foster parents feel it is essential for daughter to have a relationship with mother and son. In the foster family be willing to, and it goes on. So the court found that they thought it was essential, not just support it or open to it, that it was essential to do so. And also there was an order of sibling visitation. The son is with mother. The order mandates that the foster family and mother will continue to have contact. And there's no reason to, nothing in the record suggests that they wouldn't go along with. The court also suggested that not suggested, in the order, the foster family is to consider daughter's wishes as to whether or not there will be contact with mother. And the judge found, and as is the case, daughter does want to have contact with mother. However, she wants to have it on her own terms. She doesn't want to be forced to have contact with this woman who, over a period of years, I believe we're now 8 years from the first abuse, has continued to deny that it happened and to refer to her as a liar. That is very, very hurtful for my client. My client
does the daughter want supervised visitation? Is that what I read?
Well, she wants contact, but she wants it on her terms. She doesn't want a set order where you have to meet once during these 3 months and maybe once during these 3 months. When she wants a visit, she'll tell her adoptive parents, will become her parents. I'd like to talk to mother, and then they'll have a visit. Again, she wants it on her terms. And the suggestion that family therapy might help is not supported by the record. There was an effort at family therapy. And mother, as the judge found, mother used the family therapy as an opportunity to explain to daughter that she hadn't been sexually abused. That could not, one could argue that could not have been more harmful to daughter. What daughter needs, again, is for mother to validate and accept and say, yes, you were abused by a number of people. I believe you. She simply can't do that. It's unfortunate. She had 8 years. The first abuse was in 2012. Removal was in 2014. Mother has, since removal, mother has had 6 years or over 6 years to tell her daughter that she believed her, that she was sexually abused. Time after time, she simply cannot do that. That's what this case is about. Mother is not able to provide the validation that daughter needs. Fortunately, since 2016, daughter has been with a wonderful pre-adoptive family. The judge found that they are able to meet that need. They're able to talk her down when she escalates, when she has behavioral issues. They provide her a safe home, a home that she wants to go to. And remember, daughter testified in this case. It's brief testimony on pages 161 to 178 of the transcript. But she was extremely articulate for a young woman in what must have been an exceptionally stressful situation. She wants to be adopted by the current placement. And if she had to leave this placement, she would rather go to a random foster home than be returned to mother's care. And unless there are any other questions, I will rest on my brief.
Seeing none, that will conclude the argument in this case. Thank you all. Case is submitted.
We are live and on the record.
We now reach the sixth and final case on our hearing list today, case number 2019 P1842, Charles Mundell versus the Commerce Insurance Company.
As it may please the court, Attorney Laura Mangini for the plaintiff appellant, Charles Mundell, as the assignee of Matthew Vierthaler. Your Honors, we are requesting that this court reverse the judgment dismissing plaintiff appellant's claim, enter judgment for the plaintiff appellant on the 93A 176D claims, and remand this matter back to the Superior Court to assess damages consistent with the rulings. This relief is requested because the trial court committed an error in failing to find a violation of 93A Section 9 and 176D Section 3, where Commerce failed to indemnify its insured for the excess judgment that resulted from Commerce's negligent handling of the underlying bodily injury claim. In other words, we are asking this court to enter a decision requiring Commerce to pay for the damages that resulted from its negligence. Now, the focus of today's question is whether Commerce violated 93A when it did not pay the excess judgment which resulted from its negligent actions. It is not whether Commerce violated 93A and 176D when it failed to pay the policy limits to Charles Mundell within 30 days. Ultimately, it comes down to who is responsible for the consequences of Commerce's negligence or the innocent insured.
How did the excess, how was that, how was that as a result of the negligence of Commerce?
Sure, Your Honor. So what happened in this case was on December 30th, Charles Mundell sent a 30-day time limit demand to Commerce Insurance Company for the handling of his bodily injury claim. Along with that demand, there was over $35,000 in medical bills, medical records showing that he had actually sustained some pretty serious fractures to his face. Commerce received that letter on or about January 6th, 2016, and it went to the adjuster on this case January 7th, 2017. The adjuster was James White.
Ms. Mangini, I'm sorry to interrupt, but we understand the sequence of events. The Mundell submitted a time-limited settlement offer, and the insurance company did not agree to those terms within that time limit. But their obligation is not to agree to a unilaterally imposed time limit. Their obligation is to respond within a reasonable time. And so I think Justice Desmond's question goes to causation.
Yes, Your Honor, sure. So in this case, it's undisputed that the 30-day time limit demand submitted by the plaintiff was a reasonable time limit for this case. At the underlying trial of the 93A claim, Daniel O'Brien, the supervisor for Commerce, testified that there was nothing in the facts of the underlying claims that would have made it difficult or unreasonable for a 30-day time limit period to be imposed.
That may be true, but is 40 days unreasonable?
Your Honor, the question is not whether 40 days is unreasonable. The test under Hartford Fire Insurance Company is whether or not a reasonable insurer would not have settled the claim within the time limit demands offered by the plaintiff. And again, in this case, the only testimony, and again, the trial court found that it was undisputed that 30 days was a reasonable amount of time.
But you know, one could take a different view or interpretation of the overall sequence of events here and say that it was unreasonable to reject the offer simply because it didn't come in until 10 days after the 30-day time limit.
Your Honor, I think that's shifting the burden to the plaintiff in this case. And we also have to go back to is Commerce's duty to its insured, Matthew Verthaler, who Charles Mundell is here on Matthew Verthaler's rights as an assignee. So in this case, Commerce breached its duty to its insured by negligently failing to settle the claim within the policy limits when it had an opportunity to do so. Again, no one...
Well, it did offer the policy limits. It's the 10-day period that we're focused on. And the question is, you're suggesting that the 30 days per se, anything beyond that makes their action either negligent or unreasonable. Is that what you're saying? That because they didn't comply within the 30 days, they were negligent, therefore unreasonable, and therefore in violation of 93A 176D?
So what we're saying is they were negligent and failing to respond to the time limit demand within 30 days. That negligence in and of itself did not rise to a level of 93A violation, but that negligence did lead to its insured being exposed to an excess judgment. And it was foreseeable that if it did not respond to that 30-day demand within the 30 days, then their insured would have been exposed to an excess judgment potentially, because it was explicitly stated in that demand letter. And not only that, but during the trial, Daniel O'Brien, the Commerce supervisor and 30B6 designee, testified that he was familiar with these time limit demands, and he knew that the consequence of not responding to that demand reasonably would have been that its insured, Commerce's insured, may have been exposed to an excess judgment, which is what happened in this case. So that's where the breach of the duty to its insured comes in. This negligence then results in an unfair and deceptive act down the road when Commerce fails to indemnify its insured for that excess judgment, which its negligent actions caused.
What did Commerce have to gain by waiting the extra 10 days?
I don't think there was anything that Commerce specifically gained. Again, we're not saying that Commerce was intentionally or maliciously withholding that settlement for 10 days. The uncontroverted evidence in this case is that the underlying adjuster was just negligent in the handling of it. He received, again, I know the court's familiar with the facts, but he thought he had sent it to his supervisor. He really didn't. He never checked in to see if the supervisor had it. He never followed up with the supervisor. The supervisor in this case didn't actually even receive the adjuster's demand until February 12th, 2016.
This was the adjuster in training, right? The adjuster in training?
The adjuster in training. But again, the supervisor was aware of a demand on January 7th because he talked to the adjuster in training about it, and he never followed up with him about that demand until February 12th, 2016. And I would refer this court back to Commerce's own internal policies and procedures as to how to handle a claim in this case. According to the adjuster, and the only testimony which is uncontroverted and undisputed in this case, Commerce has an internal policy to evaluate and make an offer on a claim within 25 calendar days. The adjuster, the supervisor in this case at the 93A trial testified that 25 days time period that it has set in its internal policies is good claims handling practice and is in accordance with industry standard. And here they failed to comply with that industry standard and good claims handling practice by not making an offer within either the 25 days or the longer 30 days set forward by the plaintiff, Charles Mundell.
And there was no testimony that that was a breach of the standard of the industry.
I believe, Your Honor, that Daniel O'Brien did state that it was that it was in accordance with industry standards.
That their response was in accordance with industry standard.
No, that their internal claims policy and procedures to evaluate and negotiate a claim within 25 days or give some response thereto was in accordance with industry standards.
Well, I mean, some response. I mean, an acknowledgement of receipt and saying we're looking at it. Is that a response there too within the 25 days?
Your Honors, I would suggest that not. If you look to Gore versus Arbella, it's not enough in this case.
I'm not talking about. I'm just talking about the testimony on industry standard. I mean, the question of you know, no one is arguing, or maybe you are, that they had to respond with an offer at the policy limit, not just within 30 days, the time limit that Mundell imposed, but 25 days.
We're not suggesting that, Your Honor.
Okay.
We're just saying that is evidence that Commerce's claims handling practice and procedures, and its own internal violations of its own policies and procedures, which Commerce testified was good claims handling practice.
I understand, but I guess let me ask Judge Lemire's question in a different way, and either it'll be similar to his question, or we'll just treat it as my own. And the question is, was there any testimony about industry standards for what is a reasonable time to offer a settlement claim?
There was no specific testimony as to reasonable industry standards, other than the fact that Commerce's own internal policies were good claims handling practice. Who has the burden of
establishing that the practice does not conform to industry standards?
I'm sorry, I missed the first part of that question.
Who has the burden of establishing that the insured's conduct does not conform to industry standards?
Your Honor, it is the plaintiff's burden, but under the case law, either expert testimony or other evidence of industry practice and standards is required to meet that Hartford test. And here, again, Commerce's deponent and only witness at trial testified as to its good claims handling practice. And the supervisor in this case, Daniel O'Brien, should be considered an expert in claims handling practice. He testified he was employed with Commerce for over 20 years, first as an adjuster, and then for the past few years as a supervisor. So his testimony is enough to meet that burden. And again, the court did not dismiss plaintiff's claim based on lack of expert testimony. The trial court reviewed it on the evidence and her factual findings.
But here, it wasn't as if Commerce was not in communication. I mean, Commerce had been in communication on two occasions within the 30-day window. And also, not just we received it, but said we're not contesting liability.
Correct. So in terms of those two communications, you are correct, Your Honor, that there was two conversations between the bodily injury adjuster and Attorney Alickman. In the first conversation, there was, we're not contesting liability. Liability is 100% accepted. However, what's important to note is that at no time did the adjuster actually ever make an offer to Attorney Alickman, either $15,000, $10,000, or the policy limit of $20,000. He only told Attorney Alickman that he was evaluating the claim and getting settlement authority. He never actually made an offer. He never indicated what that settlement authority was that he was going to offer. It was just a lack of specific details as to the communication and the evaluation of this claim. For all Attorney Alickman knew, they weren't going to end up making an offer on this claim, or they were going to make a lowball offer. An Attorney Alickman should not be required to have to interpret what the adjuster's, I'm trying to get a settlement authority, I'll get back to you when I have it, what that means. And again, this isn't a case where, you know, the adjuster said, I'm trying to get a settlement authority by the end of the day. I'll give you a call tomorrow morning with the policy limits. That's a different scenario, I think, than what we have here, where on January 25th, the bodily injury adjuster states, I'm going to go get some settlement authority. And then there's radio silence until February 16th, 2016. That's a very different scenario. And I would also—
Your position is they were negligent for not settling within the reasonable time period.
Correct. It's plaintiff's position that it was unreasonable for Commerce, and therefore they were negligent in failing to settle within the time limit 30-day demand prescribed by the plaintiff, where there's no evidence that that 30-day demand was unreasonable. In fact, it's undisputed that it was a reasonable time period.
But that does not equate to that 40-day settlement offer was unreasonable a time frame.
But that 40-day settlement offer, I think, when you're looking at whether or not that's reasonable, it's taking a look at that in a vacuum as opposed to the specific facts of they knew they had a 30-day time limit demand and they knew what was going to happen if they didn't meet that 30-day time limit demand.
Well, they didn't know what was going to happen because, you know, again, that goes back to the question on causation. It's not uncommon to impose a deadline for an expected response. The establishment of that desired deadline does not equate to a threat that they will reject it and proceed to trial if the response is made within 10 days thereafter.
Well, Your Honor, I think it's reasonably foreseeable, however, that if Commerce did not respond in 30 days, plaintiff Charles Mundell was going to file a claim and try to get an excess judgment against its insured. I think that's a reasonably foreseeable consequence of failing to make that offer within 30 days. Very quickly, because I know I only have a little under 2 minutes left, I also just wanted to distinguish this case from the Palmy case that my brother in the trial court relied on. In Palmy, that's a very different set of facts. In Palmy, it was a 10-day period to settle the case over a holiday weekend. And not only was it a shortened time demand, the adjuster didn't even have all of the requisite documents to properly make a settlement in that case. That case is very different from the case here, where Commerce conceded at trial that the 30-day time-sensitive demand was not only reasonable in time and substance, but of longer time than the 25-day policy that it ultimately had. And again, in this case, the supervisor, Dan O'Brien, testified that it was the bodily injury adjuster's solely, it was his fault that the bodily injury evaluation was not completed and a settlement offer was not made before the deadline, that failure caused Werthaler to be exposed to an excess judgment, and then Commerce's refusal to pay that excess judgment, for which it was directly responsible, was unfair to Matthew Werthaler. And so I would suggest to this court that the uncontroverted evidence in this case is a far cry from the facts in Palmy that made it ripe for summary judgment. And I would also just respectfully suggest that given the totality of the uncontroverted testimony in this case, the only determination that could have been made is that Commerce negligently failed to properly train and supervise its adjusters. And in this case, that led to an adjuster negligently failing to resolve a claim within the policy limits when he had a reasonable opportunity to do so. And as a result, Matthew Werthaler is now personally responsible for an excess judgment in the amount of approximately $30,000.
And just, I know your time is running out, but your position is that negligence in not resolving the case within the 30 days resulted in a judgment of excess coverage, or in addition, excess of the coverage. And but the 93A violation was in not paying the excess coverage when they had an opportunity to under the second 93A letter, or the first 93A letter, I guess.
That is correct. That the negligent act of not tendering the policy limits within the 30-day time period gave rise to the unfair and deceptive act down the road. So,
but does 176D factor in under that 93A claim?
Yes, Your Honor. It's still a Section 9 claim.
And so 176D does not put a definitive time frame on. So no, we're still stuck with the, okay. I mean, I see your argument. I think
we can leave it there. We'll hear from the defendant.
Good afternoon, Your Honors. John Hurley for Commerce Insurance Company. May it please the court. This case was, as you know, tried jury waived before Judge Sweeney in the Superior Court in Hampden County, and she made a factual finding that Commerce did not act unreasonably in making its settlement offer of its policy limits 10 days beyond the date contained in the plaintiff's letter. And that's a factual finding, and therefore, unless it's unwarranted by the facts, it can't be reversed, or it shouldn't be reversed by this court. And I know the court is familiar with the facts, but I mean, just the whole time frame of this case, the plaintiff was injured on November 17th of 2015. The demand letter was dated December 30th, but 5 or 6 weeks later, sent to Commerce over the New Year's holiday. Friday was a holiday, the 30th was a Wednesday, Friday was New Year's, Saturday, Sunday. They got it, as Attorney Mangini indicated, I think I got to the adjuster on the 7th or the 6th. He spoke with Attorney Alickman that day and said, I've got it. It's not like Gore where nothing happened for 5 months. I've got it. I'm going to look at it. He was a trainee, as the evidence indicated. He had no authority himself. He had to speak to a supervisor to get any authority to settle the case. even $5,000 or $10,000. And that testimony was made in the record from Daniel O'Brien. So thereafter, on the 19th, the record indicates this adjuster, James White, made about a one-page written evaluation and put it in the electronic file. The one thing he didn't do was transmit that or create a task for his supervisor to look at it to know if he had authority, whether that was inadvertence, negligence, a mistake, thought he sent it and didn't. We don't have any evidence because he didn't testify. But if you see some of these file notes that are in the record, when they want somebody else who has access to the file to do something, they say a task is created. So he didn't do that. So the supervisor didn't know that the evaluation was in the file. It was there, but he didn't know it. When he found out about it on the 12th, he immediately gave authority to Mr. White to offer the $20,000. That the records indicate that authority was given on Friday afternoon about 2:30. Mr. White called Attorney Alickman on Tuesday morning. Monday was the Washington's President's Day holiday, made the offer and it was rejected. The court found, based on all the evidence, that there was no violation of Chapter 176D, that the offer was made within a reasonable time. Clearly, 40 days was a reasonable time. And Commerce, yes, it may have made the offer sooner if the communications had been made internally, but it just so happened that they weren't. I cited in my brief and attached a copy of the McDaniel case out of California, which is a federal appeals court case, I believe. And it's very similar in that there, I guess they have time limited demand. Some states have that where attorney can time limited demand. And through inadvertence between the communication between the defense counsel and the adjuster, they miscalculated how long they had to respond. They responded similar amount of time late as in this case, and the court found they reversed the summary judgment for the plaintiff in that case and entered summary judgment for the insurer, saying that it was clearly a reasonable time and that there was no basis for a 176D finding. Judge Sweeney did not actually find negligence. She said it could have been, but she then said whether it was or it wasn't, you need more than just some modicum of negligence. You need some unfair and deceptive practice, and they have to go together. And that didn't occur in this case. So therefore, she found that Commerce hadn't done anything to violate Chapter 93A or 176D in making the offer when it did. The argument that, it wasn't a violation to make the offer 10 days later, but it was a violation to not to pay the judgment when it came in is totally a bootstrap argument. If you didn't violate 93A, then you don't have an obligation to pay the excess judgment. If you violated 93A and 176D, that would perhaps trigger an obligation to pay or address the excess judgment, but that the first part didn't happen, so the second part is not available.
Is that necessarily so? In other words, there is no independent viability of a claim for ordinary negligence other than under 176D as a violation of an unfair settlement practice?
The cases I've read, I think there's a Squarey case, and I can't remember the other one, but that one in particular talks about negligence plus rascularity, I think.
Well, no, I understand the difference between an ordinary negligence claim and a 93A claim. My question is, this claim was brought as an unfair settlement practices claim, but at least in some portions of Attorney Mangini's presentation, she was making an argument, it seemed to me, that in her view, the facts here could support a claim for ordinary negligence short of 93A.
But that but they didn't make a claim for, the only claim they made.
Claim, I'm asking the question as much out of curiosity. In this field is, I've learned not to rely on instinct or analogy to other areas of the law in the field of insurance, which has some highly specialized doctrines. Just if you know the answer, is there, does 176D cover the field, or is there such a thing as a claim for ordinary negligence outside the 176D unfair settlement practices context?
The only thing I can think of, Your Honor, is there was a Sullivan case, Sullivan and Utica Mutual, where there was a negligence on the part of the attorney hired by the insurer to represent the insured, which allowed ultimately a recovery against the insurer. But that's the only context that I'm aware of.
There have been some other claims involving negligence on the part of insurance brokers or agents who failed to place coverage after they were requested to do so.
Yes, Your Honor.
Okay.
So, Mr. Hurley, your position is even if there was negligence on Commerce's part in not accepting or not pay or agreeing to pay within 30 days, that cannot rise to a level of 93A because it didn't violate 176D.
Or it factually did not in this case. There was no evidence that they had any improper intent, that they were delaying for any reason the payment of the money. They offered the money 10 days afterwards. There's no reason for them not to have done it before they just, the I's weren't dotted and the T's weren't crossed internally. So I think they had to, if there had been some delay and, oh boy, this guy's hurting for money, let's sit on this for 6 months and then we'll offer him low money or something, then you've got something, but that wasn't the facts in this case. Secondly, I just wanted to get to this expert testimony claim. There's no argument in the plaintiff's brief that I know of that their position was supported by expert testimony. They didn't offer an expert. I think what Mr. O'Brien said was their standard was to make an evaluation within 25 days. And part of that is so that it can be reviewed if it needed to be. He did make an evaluation within 25 days. He just didn't take the second step and get the authority. But so I don't think that any testimony that Mr. O'Brien might have given at trial, and I frankly don't remember it, that this was a deviation from industry standards. It was never asked in the context of an expert witness question that one would ask an expert if you were trying to elicit expert testimony. So
that would still relate to whether it violated 176D.
Yes, and there wasn't any such testimony. There's the Villanueva case, which says that you need expert testimony unless the violation is so obvious that expert testimony is not required. Maybe, if, for instance, if a doctor leaves an instrument in the patient during a surgery or something of that nature. So there wasn't. So the judge just didn't rule on my motion for involuntary dismissal for the failure to present expert testimony, but I think that's a sufficient or additional ground for upholding the decision in this case. So if there are no further questions, Your Honor, I would rest on my brief.
I'm all set.
Seeing none, thank you both. That concludes our session today.
Thank you, Your Honor.
We are in recess.